Welcome to Employment Law This Week. I'm George Whipple. Non-compete legislation is heating up on the state level. Last year, we reported on the FTC's broad attempt to ban most non-compete agreements. With that initiative now completely off the table, focus has turned to the states. In this episode, Epstein Becker Green's Spilling Secrets team digs into the latest in non-competes and restrictive covenant legislation to help employers stay on top of new and proposed laws across the country. Top of mind in this area are new laws going into effect on July 1st in Virginia, Wyoming, and Kansas. Virginia's law expands the state's existing non-compete law to provide broader protections to low-wage employees. Wyoming's law appears on its face to be a complete ban, but there are many exceptions. Kansas's law takes a different approach. Epstein Becker Green's David Clark shares some context.
Kansas's new statute is actually pro-employer rather than pro-employee, which is how I would classify the other state laws that we've been discussing. The Kansas law does not place requirements or restrictions on the use of non-competes, but it focuses instead on non-solicit provisions. So it's likely that non-competes will continue to be enforced consistent with Kansas state law.
A healthcare-focused non-compete law in Arkansas goes into effect in mid-July. That law prohibits non-compete agreements that restrict the right of a physician to practice within the physician's scope of practice. And there's still more on the horizon. Epstein Becker Green's Dan Levy tells us about pending legislation across the country.
At last check, there are dozens of non-compete bills pending across the nation in various legislatures. While it remains unclear which of these bills will be enacted into law, the legislative trend is very clear. At least 12 states have pending bills aimed at restricting the use of non-competes.
Those states include New York, Washington State, and Michigan. While some legislation is stalled, for example in Illinois, other bills are likely to pass.
My prediction, looking down the road 5 years, is that we will continue to see non-compete reform legislation across the country. I think we'll see more minimum salary thresholds. I think we'll see due process protections like review periods, mandatory advice to seek counsel before signing, things like that. That's what I think is going to be most common.
In this climate, Epstein Becker Green's Carolyn Boucek recommends that employers stay up to date on the latest developments.
That's easier said than done for sure. As Dan discussed earlier, employers are increasingly finding themselves limited by local and state legislation when entering into and enforcing non-competes. But that doesn't mean that they're out of luck completely. They can often use other types of restrictive covenants to achieve the same end.
These options include NDAs during employment and post-employment tools like non-solicitation agreements and garden leave provisions. That's it for this week. Subscribe to Employment Law This Week wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.